Welcome. Today's video is brought to you by the Oregon Native American Chamber, ONAC, and the Small Business Legal Clinic of Lewis and Clark Law School. The goal of this video is to tell you a story about how your small business can protect its products and intellectual property using utility patents.
Hi, my name is Rachel Dreilinger, and I'm a member of the Navajo Nation. My grandmother is Flora Sombrero, and her clans are Many Goats and Red House. My grandfather is Billigana. His name is Rulin Lind, and Billigana means white. I'm a biomedical engineer. I've been an engineer for about 21 years.
In 2014, Rachel co-founded Neuromedica in Oregon City, Oregon, with a surgeon at the Oregon Health and Science University. The company is developing technology to protect and close the membranes punctured during spinal surgery.
At my company, Neuromedica, it's really important for us to protect our IP, that's intellectual property, and also to attract investors. One way we do that is developing our patent strategy by working with multiple patent attorneys and submitting and applying for patent applications. So we do.
Utility patents protect new and useful inventions or processes, or a new and useful improvement to an existing invention or process. Usefulness. This means that it accomplishes a task or has a purpose or benefit. This could be a process for making clothes or a piece of clothing itself. These have uses. However, art or a new design on a useful object is not useful. These would be protected by copyright or design patents. Newness or novelty. This means that you must have invented the useful invention or process or made a significant improvement. Further, the invention must be significantly different than existing inventions. It cannot be an obvious improvement on existing inventions. This level can be tricky to determine. Think about the heart of your invention. Is it something that's useful and not about a pleasing design or your own artistic spin? Is it also truly new and not obvious from previous inventions? Rachel's invention is useful in helping a person heal faster from spinal surgery and was new and different than the sutures and clips previously used.
At this time, we have multiple patents. Some have already been issued, and we also have international patents running as well.
Be careful. You have 1 year from disclosing an invention to the public to when you must file a patent application or you lose your rights. This includes selling, describing, or publishing information about your invention to the public. But this does not include developing or testing your invention with a small group of trusted people. What is protected by a patent? A patent gives you the right to control how your invention is made and used. You can keep it to yourself, you can allow others to make and use it, or you can sell and market it yourself. This protection lasts for 20 years.
Developing a patent strategy is a lot of work and really expensive. We've worked with multiple attorneys, and the fees can be as much as $50,000 a year for our patent work. So it's extremely important for us to obtain the funding to support our patents and protect our technology the best way that we can.
Obtaining a patent can be difficult, expensive, and time-consuming. You need to file a patent application with the United States Patent and Trademark Office. A patent examiner will review and likely require changes to the application. The process typically takes 2 to 3 years, and most people hire a lawyer. The average cost for a single patent can be $5,000 to $15,000. So, is a utility patent right for you? First, what is the heart of your invention? Is it something new and useful? Is it not primarily a new design or your creative flair? Second, why do you need it and what will you use it for? Do you need to control how the invention is used in the world? Third, are there other options? A recipe is patentable, but it might just be easier and cheaper keeping it secret. Fourth, are you ready? The patent process is long and expensive. Is your invention ready, or do you still need time to perfect it?
One of the most important things is if you have an invention to write it down on paper, draw pictures of it, and sign and date everything that you do. Another really important thing is to save money as much as possible early on. You can do a lot of the work yourself. So I tell people to go onto uspto.gov or onto Google Patents and do their own searches before they hire anyone, just to see if their technology is already patented.
Get help. Talk to other inventors. Consult a patent attorney or a legal clinic with reduced fees. Read patents on google.patents.com. Go to uspto.gov for more information about the patent process. From ONAC and the SBLC at the Lewis and Clark Law School, thank you and good luck.
There have been lots of highs and lots of lows and successes and failures. But working through the patent process, learning more about it has just been a really wonderful part of my career, and such an important part of the commercialization process in general. So I just wish you the best of luck in going forward with your invention.